And I think that is where we kind of see it as a positive of where for the first time from a business perspective, you're not just sort of collecting everything you can collect and just put it in a warehouse somewhere, but you're trying to really figure out what is it that I need. And obviously when we start thinking about it from a marketing perspective, Andrew, then it does become the question of like, well, what data do I really need? Which aspects of the data that I have are really one critical to being able to market effectively and intelligently to people. And then, at the same time, we also know as marketers, we're often working with lots of different tools that have kind of a range of, anonymous to, anonymous data, maybe through a Google Analytics, but then you also have a CRM like a Salesforce that has, user specific data. So Andrew, from your marketing kind of perspective, where do you see, I guess one, maybe some of the tools that may be most impacted by this or some of the aspects, and then as people start to try to really think critically about what data they really need, where you see from a marketing perspective the critical bits of data that people would want to really be thoughtful about how they maintain it.
Well, from a marketer's dream scenario perspective, we'd be able to tie sales and revenue and customers' lifetime value back to a website visit or the viewing of an ad or an impression of some sort, or engagement on social media. So in some ways, the law and any efforts towards greater consumer data privacy kind of limits our ability to track on an individual one-to-one basis this customer engaged with your brand in these channels and eventually converted, whether that's in a store or online or through a direct sales channel of some sort. That's the marketer's dream. But in 50 years of gathering more data about marketing, and in the last 10 to 20 years of actually having digital and large amounts of data at scale, nobody's been able to crack that nut consistently and reliably. And even large brands that have lots of resources and are throwing large teams of analysts and data collection mechanisms at this problem have not been able to solve this issue. So I think for anybody concerned that this is going to limit our ability to market better and determine the ROI of our marketing efforts, we have to be realistic about what we're already able to achieve. I think it's going to further push us towards looking at data in aggregate, right? We obviously can't track individual users at scale without running into some of the complex issues around data retention and privacy. So we have to be more creative in gathering the data that we're looking for and then modeling the behaviors with consumers and the interactions they have with our brands to track them through to that eventual purchase. So the subject of tools you mentioned, which is great because that's exactly where I was going to go with this question, is a lot of us as marketers don't have our own in-house, internal systems for tracking website visitors or conversions or sales that happen online or offline. We depend on Google Analytics or Salesforce or HubSpot or any of the other large platforms that do a lot of the processing behind the scenes for us. So in a way, that's a good thing. Those platforms themselves have to become compliant. And about 2-3 years ago, when GDPR was coming into the fore, we had to work with each of those vendors to make sure that the data we were collecting were compliant. They were on the hook for processing and storing that data in a compliant way. So a lot of times we just got notifications that these settings are changing. This data is going to be sunsetted or scrubbed after a certain amount of time, and we have some control over that as well. But ultimately, it's a partnership between a marketing agency, or a marketing organization, whether that's in-house or an agency, the business decision leaders, and any technology partners. And we all have to be in agreement that there's enough data coming in that we need to be able to do our jobs. We need to be able to track our performance and our success without running afoul of the laws. So what's the next best situation that we can put ourselves in? Or what's the best data, or what's the best thing we can do with the data we have access to? And in most cases, we're still able to market just fine. We're still able to track performance and outcomes of our marketing efforts using the data that we have and the tools that we're using while still being easily compliant within the privacy laws. So there's no large risk as long as you're partnering with your stakeholders and with your vendors or partners to make sure that everybody's on the same page with what we're gathering, why we're using it, where it's being stored, and making sure everybody up and down the chain is compliant.
And then I think that is something that I certainly relate to, Andrew, as far as from marketing perspective. We see how much data often that companies and clients have that's going unused. So they're in general, if the outcome of this is that, hey, everybody's taking a little bit of time to think about the data they're gathering and what they're really doing with it, there may not be potentially that much of an impact depending on what it is. The other sort of important caveat to this legislation for now, of course, is that it's only applying to companies that collect at least the user data of 100,000 users a year, which is going to exclude a lot of small businesses. My question for you all is, Presumably, it's not going to be that way forever. Presumably, this is to give kind of like a longer lead time again to smaller companies that may not have the resources in-house to kind of manage these things. But is that a number that you imagine will gradually go down over time? And where do you see, again, there's sort of like the enterprise perspective on this, but also a small business perspective. Again, even if it doesn't apply to them right now, are there some of the steps that they could take, should take, that might look a little bit different? What do you all see for that landscape?
If I can jump in, because this kind of meshes nicely with the point I wanted to make, regardless, and that is that Randy is absolutely right to identify certain best practices that I think now should apply to even those institutions that are not covered by this legislation. So the idea that you should only be sitting on data that you need. You shouldn't be going through the time and expense of acquiring data that you don't need, and that even worse can subject you ultimately to liability if you lose it in a breach, or you've handled it now improperly pursuant to this statute. What's interesting is that while that has always been a best practice, this law actually makes it a required practice. Subsection 574 requires that controllers limit the acquisition of their data to only what they need to do their business. And I think that's interesting. So to answer then your question, Derek, I think that people who are currently sitting under, businesses that are currently sitting under the threshold of this law, should still be looking at its general tenets and exactly the sort of things that Randy was talking about, and saying to themselves, I may not be required to do some of these things, but it is still absolutely a best practice. I still could be subject perhaps to litigation that's grounded in some law outside of the statute if I'm not doing it. Critically, my business reputation is at stake. Nobody wants to have their data breached and stolen, and no company wants to have to send a letter to a customer of theirs that has happened, particularly when the subject of that breach is data that they shouldn't have collected or should have disposed of years ago. So yes, if this law does not apply to you, if you're under the threshold, still be guided by it. And yes, you should also expect that eventually you are going to be under the auspices of a law that has a lower threshold, because that's certainly what's happening here. We have the supranationalist laws in Europe, and now we're having the larger states addressing these issues. We've even got some smaller states. I think Maine and Nevada are passing or working on similar legislation. It's going to trickle down. It absolutely will, and the product might be better by the time it trickles down to you, because there'll have been so many test groups by the time it gets down to smaller businesses. But expect that one day you'll be on the hook for a compliance regimen, and it pays to just get your best practices in order right now.
Yeah, and I think, to your point, Chris, we even see that with California, right? Because right on the heels of enacting CCPA, they came right behind it with CPRA, strengthening that privacy law, kind of lowering some of those thresholds within it to, further enforce compliance and put more power in the hands of the individual consumers. So I totally agree. I do think that the bar will continue to lower, but businesses shouldn't look at this as a burden, an unnecessary burden, or an unnecessary compliance requirement, right? Or a burden, if you will. They should really look at it as an opportunity to really showcase that they are advocating on behalf of individual consumers, and that they are, fighting for and standing up for their individual privacy rights, and being assertive in public with how they are protecting individual consumers' rights, and really making it easy for consumers to provide, or accommodate these requests for information access, or the right to be forgotten, things of that nature. I mean, these are opportunities to displace you from your competition, because people will always want to favor businesses that have their best interests in mind.
And that's a great point. And I think, Andrew, from again, coming back to the marketing angle on this, there is that tear moment. If you're, a marketer and you work in a company and there is a data breach, and all of a sudden you're basically having to send really bad news to everybody that you work with. But at the same time, especially for companies that are in Virginia that legally might be obligated to get out in front of things now, maybe there is that chance. How would you think about kind of ways to frame this, or ways to use this to your advantage as a way to kind of show that A, you really do care, and B, that you can, kind of publicly let people know what data that you have, so that you're not one of those kind of, scary black boxes of data that people don't know what you have on them.
Yeah, I want to piggyback on Randy's comment. I think companies that lean into this as an opportunity are going to find themselves with a competitive advantage over time, right? And looking at some statistics right now, about 30% of web users, at least on desktop computers, use some sort of ad blocker, right? There's already a movement towards privacy, and at least privacy in terms of stop targeting me with ads based on my browsing behavior and who I am. You're still going to see ads are going to be less relevant. 87% of people say that they are less likely to do business with a company if they don't trust their data practices. Right? That's almost 9 in 10 consumers are willing to switch companies or switch brands or switch providers if they don't feel like their data is safe. The challenge we have as marketers is letting people know that their data is safe, right? And being able to back that up and communicate that and message that. So one of the things that we are advocating for at Workshop Digital, and we've seen be successful with GDPR and CCPA rollouts, is leading with not necessarily as your main benefit statement or your main feature, but certainly featured prominently the fact that we care about your data. You can trust us with your security. Here's everything you'd want to know about our privacy practices, our data security practices, whether that's simply in a privacy policy that's standard and required on websites, or if it's actually something that you build out more content around so people feel like they can trust you. And that's especially important if you're dealing with sensitive information, right? Not just my name and email address, that's sensitive enough. But if you're dealing with phone numbers, health information, payment information, social security numbers, if that's stuff you need to collect to do your job and process that data, there are certainly ways that you can provide those warm, fuzzy feelings without being, overtly so focused on privacy that you're ignoring the other benefits that you're providing your customers. So I think there's a big movement towards privacy in general, whether consumers are out front leading that or whether it's state regulators bringing in legislation to hold companies accountable. I think ultimately there's no way we're going backwards from here, right? So there's no situation that I can foresee where laws like this get rolled back. To Randy's point, they're going to get tightened, they're going to get strengthened, and I think ultimately companies that just willingly resist at that point are just being are being deliberately and intentionally avoiding the situation and doing what they know to be right. And I think consumers will respond. So to get buy-in, we've got to paint the opportunity to say, this is not just a cost of doing business or a burden. It's a way to get some advantage, get first mover advantage if your competitors aren't talking about it, or to build that into your practice and your products so that there's no doubt that you're putting privacy in the forefront.
One thing that, sorry.
Go ahead, Randy.
I was going to say, one of the things that we can track is if we go back a few years and look at some of the hurdles that say Amazon Web Services and Microsoft Azure had to assuage some of the concerns of enterprises that they were trying to convince those businesses to bring their data to them. Trust us, we have your best interests in mind. And you can look at both of those as good examples. They set up a compliance center on each of their sites. And inside of those compliance centers, they list out all of the frameworks, all of the different obligations that they adhere to, and they freely make it available if they have a SOC 2 Type 2 or some other type of third-party attestation and certification. They make those available on their website. So, to Andrew's point, it's not just them saying, hey, trust us, we're really good at what we do. They're also showcasing, this is our statement, but look at all these other persons and look at the testing and the results that they've provided as well. And now you have the full concert of not only the organization, but all of the third parties that have also witnessed and weighed in on their ability to protect consumer rights as well.
Yeah, I think that what we're all kind of talking about and envisioning here is sort of a new approach to the privacy notice on a site, right? It no longer viewing it as this kind of humdrum legal boilerplate that's just a drop down on some, that resides somewhere on your webpage, but potentially making it a focus of your pitch to existing and potentially new customers, and finding a way to make those privacy notices more engaging and to really not just be kind of setting forth a recitation of the minimal things that you're doing in order to comply with the law, but the way in which what you're doing makes you different and better than your competitors. And really sort of moving this notice from the dusty confines of your website to someplace where people will see it and click on it and engage with it.
Yeah, I had this panic moment last night as I was reading through some more materials to prepare for this conversation. And I had that oh crap moment. Are we even practicing what we're preaching right now? Right. So I went and I reread, which I've never done. I actually went through and I read our privacy policy on our own website that was probably built years ago, and I was actually proud to see that we're practicing what we preach, and a lot of those things that are now becoming best practices, disclosing how you're using the data, who you're sharing it with, what it's used for, when you scrub it, and how to opt out, how to request your information, how to get removed from that. Even for a small company like ours, it's not that difficult, right? It doesn't require a lot of automation. It doesn't require expensive tooling behind the scenes or large teams to go in and make this right. It requires just a little bit of attention and caring about the customer to go in and rephrase how you're positioning your privacy structure, right? And it's not, doesn't depend on building in new technology or infrastructure at the small business scale. For large businesses, definitely call Randy. But you need that automation and that systemization on the back end. But for most of us, it's just a matter of doing the right thing, right? Being clear and transparent about what you're trying to accomplish. And I think consumers are going to appreciate that more and more as they catch on to what's going on.
And it probably, I think, Randy, was great to think about examples of, okay, who's already doing this and where might some of that messaging live as far as cloud platforms that are hosting this stuff, that really the core of their marketing pitch is about how they handle data, that if you just want to go somewhere to sort of have, some language, some copy that you could even take that's going to make sense. We're probably some companies that are based in California that are doing this already, but to think about, people that, businesses that survive solely on warehousing, data that's subject to HIPAA and those kind of things, where that messaging really is critical to their business, that may be a great place to get not just messaging that puts you in compliance, but messaging that really helps you stand out.